Have you ever wondered what the heck precedent is? If so, stick around, because we're about to explain it to you like you're 5 years old.
I'm not sure the entire legal profession is ready for the 5-year-old version, but I'm here for it.
Welcome to Dejargonize, the podcast where we take one confusing term and explain it in plain English. I'm Felix.
And I'm Ruby.
Today, we're talking about precedent. It's a word you hear constantly whenever there's a big court case in the news.
Right, and it always sounds incredibly important, but I don't think I could actually define what it is or how it works.
Well, at its core, precedent is just a previous court decision that acts as a guide for how future, similar cases should be decided.
A guide? So it's a strong suggestion?
It's a bit more than a suggestion. The formal principle behind it is called stare decisis.
Teasing? Oh, we're starting with Latin. Bold move.
Stick with me. It just means to stand by things decided.
Okay, to stand by things decided. That's actually pretty straightforward.
Exactly. And there's a really useful way to think about it. Precedent is basically a rule about who has to justify their decision.
What do you mean?
In general, the tone follows the precedent. If they make the same ruling that a previous court made in a similar case, they don't need any special explanation. That's the default.
Right, they're just doing what's been done before.
But if a judge wants to depart from that precedent, they carry the entire burden of explaining why. They have to argue for why this time should be different.
Oh, I get that. So the default is set to same as last time, and going against that default requires a whole lot of extra work and justification.
That's the perfect way to put it.
Okay, so it's a strong default. But does that mean a judge in, say, California have to follow a decision made years ago in Florida?
That is the perfect next question. And no, they don't. This is where we get into the difference between binding precedent and persuasive precedent.
Okay, let me guess. Binding means you absolutely have to follow it, and persuasive means it's a really good suggestion.
That's it exactly. A precedent is only binding if it comes from a higher court within the same legal system. So a local court is bound by its state's Supreme Court, and all federal courts are bound by the U.S. Supreme Court.
But the court in California can look at that Florida case and just ignore it?
They can't ignore it, but they don't have to follow it. That Florida decision is considered persuasive. The California judge might read it and think, wow, that's a really smart way to handle this, and choose to adopt that reasoning. But they're not forced to.
So it's like a direct order from your boss versus a useful tip from a colleague in another department. One you have to do, the other is just good advice you can take or leave.
That's a great way to put it, but it gets even more detailed. Even inside a binding decision from a higher court, not every single word is binding.
Skeptical? Really? How can part of a court's ruling not be the ruling?
Because the only part that's truly binding is the core legal reasoning that was essential for the final decision. It has another one of those Latin names, the ratio decidendi.
Okay, the ratio something. What does that actually mean?
It just means the reason for the decision. Think of it as the legal principle that the whole case hinges on.
So what's all the other stuff in the document then?
That's called dicta. It's basically everything else the judge wrote. Observations, side comments, hypothetical scenarios. It can be interesting and even persuasive, but it doesn't have the force of binding law.
Huh, so there's a built-in escape hatch. A lower court judge can say, I'm bound by the core reason of that previous decision, but this other point they made was just dicta, so I don't have to follow it.
Precisely. And that leads to the biggest tool a judge has for navigating precedent. It's called distinguishing a case.
What does that mean? To distinguish it?
In general, the judge argues that the facts of the case in front of them are so different from the facts of the earlier case that the precedent just doesn't apply.
So they aren't saying the old decision was wrong, they're just saying my case is an apple and that precedent was about oranges.
That's exactly it. They're saying the precedent is good law, but it's law for that specific situation, not for this new, different one.
Okay, so between distinguishing the facts and pointing out what's merely dicta, it sounds like there are a few ways for a judge to navigate around a precedent they think doesn't quite fit.
Exactly. And that gets to this really common misconception people have about how this all works.
Which is what?
Well, you hear two extreme views. Either that precedent is an iron law that can never, ever be broken, or the total opposite, that judges just ignore any past ruling they don't personally agree with.
And the reality is somewhere in the middle, I'm guessing.
Way in the middle. Precedent is powerful, but it's not permanent. Higher courts have the ultimate escape hatch. They can overturn their own previous decisions.
Surprised? Wait, really? So a Supreme Court can just look back at a decision from 50 years ago and say, nope, we got that one wrong?
They can, and they do. It's not something they do lightly, of course. It's a huge deal. But it's a critical way that the law can correct itself or adapt to changing times.
Okay, that's a big one. What about courts on the same level? Let's say there are two different high-level courts in two different parts of the country. Does one have to follow the other's precedent?
Nope. Courts at the same level do not bind each other.
So you could have conflicting rulings where one court says one thing and another, equally important court says the exact opposite?
Thoughtful. You absolutely can. And that's how you end up with the legal patchwork, where the law on a certain issue is different depending on where you are in the country.
That sounds incredibly confusing.
It can be, but that conflict often serves a purpose. It's a signal flare to the highest courts, like the Supreme Court, that this is an issue that needs a final nationwide answer.
Oh, I see. So the conflicting decisions actually create the reason for a higher court to step in and settle it once and for all.
Exactly. It's all part of the system. Precedent creates consistency, but these escape hatches, distinguishing, overturning, and courts not binding each other, build in the flexibility for the law to evolve.
So with all these rules and escape hatches, what's the big picture? Why does precedent matter so much?
Ultimately, it's about predictability. If the law can change wildly from one day to the next, or from one judge to the next, nobody can plan their lives. Precedent makes the law stable and consistent.
So everyone is playing by the same set of rules, and those rules don't just change on a whim. That makes sense.
Right. But there is a huge, critical point we have to make here. This entire system we've been describing is a feature of what's called common law countries.
Wait, what other kind of law is there?
Lots of countries, like France and Germany, have civil law systems, and they don't have binding precedent or stare decisis at all.
Surprised? At all? So how do they keep things consistent? Is it just a free-for-all?
Not at all. In their systems, past court decisions are seen as persuasive, but they aren't strictly binding on future judges. They build consistency through a large body of uniform case law over time, rather than relying on a single ruling to set the standard.
Huh. So it's a different path to the same goal of making the law predictable.
Exactly. So it's crucial to remember that when you hear people talking about precedent, they're talking about how it works in places like the US and the UK, not everywhere.
Okay, I think I've got it. So if I had to boil this entire conversation down to one sentence,
Precedent is just the rule that says the default answer is same as last time, and the burden is on anyone who wants a different answer to argue why.
That's perfect. The only thing I'd add is the big caveat. That's how it works in our legal system, but not everywhere else in the world.
Right. I'm still a little fuzzy on how they manage without it, but that might have to be another episode.
It might, but for today, you nailed it.
Well, if this made the idea of precedent finally click for you, we'd love it if you'd subscribe wherever you listen to podcasts so you don't miss our next attempt to de-jargonize the world.
Thanks for listening. Bye, Ruby.
Bye, Felix. Bye, everyone.